Hello and welcome to another exciting lecture of CA Inter Corporate and Other Laws revision series in English language only. If you have missed our earlier lectures, then I'm leaving a link over here. Just click on the I button and you'll be able to watch all the earlier revision lectures that we have covered till date. In this video, we are going to discuss the General Clauses Act 1897 with the help of this beautiful, colorful chart book. If you would like to make this chart book your own, then do visit my website TheoryMastersLearning.com and place your order today. Let's begin with the General Clauses Act 1897, and I'm going to cover the entire act in just 4 pages. Yes, just 4 pages and the entire act will be covered. If you're watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to now your channel Theory Masters Learning and hit the bell icon so that you get notifications for all the upcoming videos, especially in English language only. Let's get started. Now, the General Clauses Act 1897. Before we begin with this act, let us go through some basic concept as to why are we studying the General Clauses Act and what was the main aim behind introducing this act. Now, let us imagine a situation where you have already cleared your chartered accountancy. You have become a chartered accountant and you're sitting in your AC office working, and your friend comes to you with this problem. He says that I am referring this particular act, but I'm not able to decide whether this act applies to me or not. There are so many terms, there are so many provisions which I'm not able to understand. You are a chartered accountant. Please help me understand these terms so that I can decide whether the act applies to me or not. Now, you as a chartered accountant pick up the book, whatever material that he has got, you start going through the act. You don't find the meaning, you don't find the definition of those words in that act. You start panicking. Now, you can't tell the client that, sorry boss, even I'm not able to understand these words and terms, you please ask someone else, refer the dictionary, that's the best. The client will never come to you, you will not get business. Now, there are so many acts contain so many different terms. Now, a lawmaker tries to define these words, these terms in the act itself, but sometimes it is not possible to define generally used words, no? So the problem arises that if there is a general word, or if there is a word which is used in many acts, we can't go on defining it in every act. So lawmakers have decided to define those words, to define those terms in just one act, and that act is the General Clauses Act. If you are unable to find the meaning of any term, any word in that particular act, then you can refer to the General Clauses Act. But this act will not define each and every word. See, go through the name of this act. It is the General Clauses Act. It means that this act tries to define general words. It tries to define the commonly used words in many acts. If you want to try to find out the meaning of a particular word, then you should search it in the act itself. You will definitely get the meaning of that word in that act. But if you're trying to find general words, like what is the meaning of commencement? In Contract Act, that is the first act you must have studied in foundation. We discussed that the Contract Act came into force on 1st September 1872. It commenced. What is the meaning of the word commence? Like, commence has a general meaning, it may have a technical meaning. What exactly is the meaning that we need to consider for law? That is explained here. What is the meaning of the word affidavit? What is good faith? That is one word which we have come across so many times. Like, you must have studied that in CA Foundation Sale of Goods Act, Partnership Act. You must have studied it in Companies Act also. What is the meaning of the word good faith? If you go to find the definition, very rarely you will find these definitions in the act. Now, you cannot tell your client that I don't know, even I can't find the meaning of these words, I don't know what it means. So as a chartered accountant, we want to inform you that there is an act which will help you in such a situation. Refer the General Clauses Act for these generally commonly used words. Now, instead of defining these words again and again, the same definition will apply in different acts. Acts will become bulky, there will be a lot of repetition. In order to avoid that, we have formed a separate General Clauses Act wherein we define these generally or commonly used words. These are clauses. Do you remember studying in foundation that an act is first divided into chapters, and the chapters are then divided into sections, sections are divided into subsections. Then we have clause, subclause. Yes, sometimes in the section directly, we jump to clause. What exactly is the meaning of this word clause? Clause is something which is either independently defined, okay, or over here you are defining a section, then you want to explain something in that section itself. It is forming a part of that section, so you go to subsection. But when you want to change the point, you know, in that particular section you want to change the provision, then you may go for clause, or something you want to explain in detail in that subsection, then you go on further explaining it, that is clause. But as far as definitions are concerned, we use the word clause instead of subsection. Why? Because every definition is different. Like say for example, you study section 2 clause A. Section 2 clause B, like in Contract Act we discuss section 2 clause A defines offer, B defines acceptance. Now, why are we using the word clause over here and why not subsection? The reason is that each of these clauses are discussing a separate concept, an independent concept, a different concept. They are not interdependent on each other. If they are interdependent, then we will definitely use the word subsection after the section, because to show interdependency. But here, since each definition is distinct, it is separate, it is not dependent on each other, we use the word clause. So the word clause actually means a definition. Yes, so over here the word clause actually means definition. So if I want to now bring everything together, the General Clauses Act actually tries to define the generally commonly used words. If we are trying to define them, this again shortens the language of law. That is the main aim of definition. Instead of explaining the word again and again in that same act or in every act, if we go on defining that word, it will make the acts very bulky. So in order to shorten the language of law, in order to bring a lot of uniformity, we define few words. Now, the sections that we are going to cover in the General Clauses Act are section 3, which includes the definition, to section 4A, these are general definitions. Then we have section 5 to section 13A, which cover the general rules of construction. Section 14 to 19, they cover the powers and functionaries. 20 to 24, they are provisions relating to order, rules made under the enactment. 25 to 30, these are miscellaneous provisions. Here we are going to discuss all the important provisions for exam. So what is the objective of the act? The objective of the act is to define commonly used words here. Okay, so the commonly used words are defined over here. That is the meaning of the word clause that you have seen in the main heading of the act. This avoids repetition. Now, this is the whole purpose of definition of word repetition. Now, if I use the word director in Companies Act, now the word director is used so many times, multiple times in the Companies Act. If wherever the word is defined, wherever the word is used, if I go to define that word every time in the act will become very bulky. It will contain the same definition again and again. So instead of doing that, instead of defining the word, explaining the word again and again in the sentence, we generally define it. Like in the Companies Act, you must have studied section 2. Preliminaries, that is the chapter in your syllabus, that defines the words once. Wherever the word is used in the act, you will apply that definition. Now, there are certain commonly used words. Now, law says that why do you need to define that word in every act? Define it at one place in the General Clauses Act, and wherever that word is used, in whichever act it is used, it will have the same meaning as given in the General Clauses Act. All the definitions are now placed at one place. So if I want to refer to these meanings, what is the meaning of the word preamble? What is meaning of the word act? What is an affidavit? What is the meaning of central government? Now, there are so many places wherein they just say the government will. Which government? Central or state government? All that clarification is given in the General Clauses Act. So it brings all the definitions at one place. You need not search for those definitions. The definition which is specific, like I have written over here, steps. First, you will try to find out the definition in the respective act. Okay, this is step number 1. The peculiar definitions which are very specific to that act, those words will be defined in the act. But if you fail, then only you will refer the General Clauses Act. If suppose you find the definition in that respective act, then you need not come to the General Clauses Act. Yes. So over here, you will refer it only when you do not find the definition in the respective act. So all the definitions which are common, they are now grouped at one place. It brings uniformity. Now let's say that I use the word director. Okay, I always give this example because it is something which we generally understand very quickly. The word director, it has so many different meanings, no? Like if suppose I am referring to director of the company, he's someone who manages the company. But what if I am using the word director as far as entertainment is concerned? So director can be director of a movie, can be director of a play. So if one word is a very generally used word, you may consider director of a company. I may consider the word director as director of a play. There is confusion because the word is so common that it is open to different interpretations. Therefore, law says that if there is no definition, imagine there is no definition, if there is no definition either in general clauses act or that particular act like companies act, if there is no definition of director, how will we understand what is the meaning? So it tries to bring uniformity. If three people are reading the act, they will understand the word director in the same manner because it is properly defined. Okay, so it brings uniformity. So different people will refer this definition and have the same understanding of that word. These questions, no, students, like what is the purpose of the act, what is the objective of the objective and purpose, it can be asked as a 2 mark, or if it is asked in a combination, then as a 4 mark question. What is the purpose? To provide the general definition. See what word is used over here, to provide the general definition, because the specific definitions will be given in the act itself. So this tries to give general definitions for all the central acts. Central act means acts which apply to the whole of India. So they give definition for all the central acts and regulations, but there is no definition in those acts or regulation. Okay, it shortens the language of law and it also avoids repetition. So by defining the word at one place, we are shortening the language of law and also avoiding repetition by explaining the word again and again. One more example of that, student, how does the act help to shorten the language of law? Now see, this is a very good example which you will find in the module also. Whenever the act provides that the court will have the power to appoint, suspend, remove a receiver, the lawmaker, the legislature, the lawmaker says that why do you need to explain all this? This person can be you can appoint, suspend, remove. You need not write all that, because the person who has the authority to appoint will automatically have the authority to suspend and remove as well. So it is sufficient, it is sufficient if you simply write that the court may appoint the receiver. It is implied, it is understood that if you have the authority, if the court in this case has the authority to appoint, the court in this case will also have the authority to remove or suspend. So they are saying that shorten the language of law, you need not provide all these explanations. But yes, I don't think they are able to achieve this to a very great extent. We do require clarifications because people who read these acts, they may not know what is written in the general clauses, they may need clarification. So at many places you will find that there are extra words, explanations given, but the aim of general clauses act was always to shorten the language of law. It gives clarification when one word has different meanings in different acts. So every act may interpret the word differently. So to bring uniformity, we say that you all will refer this definition which is given in the general clauses act. This act, yes, what is the application? This is just a guideline, it's not some mathematical formula. I always tell this to my students that law is not like maths. See, in maths, if you apply a formula to any sum, the answer will you will be able to apply and you will get a standard answer also. But in law, you cannot apply one provision uniformly to all the situation. Everything depends in the context, everything depends on the facts and circumstances of the case. Let's say, for example, killing, that's a criminal offense, but what if the person killed in self defense? And we do consider that, yes. So in that case, you cannot just apply law as it is. What we are trying to give in the general clauses act, these are guidelines, but please consider the facts and circumstances, the context in which you are using. Like the word director, you can use that example here also. If the word director is used in the context of a company, it means someone who manages the company. If it is used in the case of entertainment, it may mean the director of a play, it may mean director of a theater. He is someone who directs the actors. He is someone on whose directions the play is run. So that the word, it can be read so differently. So you also have to apply the context. They do not apply automatically. Facts and circumstances are to be considered. Words and provisions are to be read in the context in which they are used. So these are the keywords which I have highlighted for you. If you have the chart book, then please highlight that with me. Now, before we jump into the definition, first we should understand, we should have some basic interpretation of few terms, like what is the meaning of the word preamble. Now, you will come across this word preamble in the interpretation of statutes also. But yes, since it is a word which is defined in both the chapters, in the exam, they will specify whether they want you to write the definition as per the General Clauses Act or whether they want you to write the definition as per the interpretation of statutes. But if you compare both definitions, they are similar. Now, what is preamble? I'll highlight the keywords for you. It is a brief summary of the act. It expresses the scope, object, and purpose of the act. So what is the object? Object and purpose, they actually mean the same. Okay, so the word object and purpose, they actually mean the same. Now, I want to know to what extent, to what all does this act apply? Like, say, for example, if you see the preamble of a Companies Act. Okay, if you see preamble of the Companies Act, the preamble of the Companies Act and the long title, they are the same only. It is an act to consolidate and amend the law relating to companies. The word companies is used. It means that this act applies to companies only. It does not apply to proprietary business, partnership business, HUF. It is a law which is made to amend and consolidate the law relating to companies. It is so very clear. That is given in the preamble. So if you have any confusion whether this act applies to my business or not, refer the preamble. In the preamble of the Negotiable Instruments Act, it is written that it is a law which is made to amend and consolidate the law relating to promissory note, bills of exchange, and check. No other negotiable instruments will be covered by that act. This act applies to only those three negotiable instruments. So in this case, the preamble will help you to define the scope of the act, to what extent, and to what instruments or to what kind of contracts, to what kind of organizations does this apply. So it is a brief summary of the act. But yes, the preamble cannot explain everything. So law also says that in case of confusion, yes, preamble will help you to understand the main purpose of the act, but it is to be used. This is important. Preamble will be used only when the language of the statute, that the law which you are studying, it is not clear. So what we do is we refer the section, we go through the provisions of that section. In case there is any confusion, like words are not very clear, the sentences, they are ambiguous, then if there is confusion, only then you will refer the preamble. But the preamble is saying something else, section is saying something else, and in that case, you cannot override the statute, you cannot override the law. The statute will prevail, not the preamble. It is the main source of understanding. So we will highlight that it is the main source of understanding of the lawmaker. What did the lawmaker have in mind? Like the Hindu Marriage Act. This is an act which is applicable to Hindus only. So what if one person is a Hindu, other person is a Christian? Will this apply? No, it will apply when there is marriage between two Hindus. The preamble is very clear that both the parties have to be Hindus. So whenever there is confusion in the section, the words are not very clear, sentences are not clear, we will refer the preamble. Now all these points are important because you need to mention all this in the definition. The question will be of around 4 marks, 3 to 4 marks. So you will mention these 5 to 6 points. Then we have a bill. Now, we have always studied the word act, but an act to pass is introduced in the form of a bill. So bill is nothing but the draft version of the act. Okay, it is a draft of the legislative proposal. It is put in the proper form. Okay, the bill is put in the proper form, then it is placed before both the houses of parliament. It is actually first given to the standing committee. The standing committee will study it, whether it is worth discussing. Then they will place it to the house of parliament. It will be passed by both the houses of parliament. Okay, it will go to the houses of parliament, the Lok Sabha and the Rajya Sabha. Once it is passed by both the houses of parliament, then it will receive the assent of the president. It will receive assent of the president, and once the president gives his approval, then this bill will now become an act. So what is a bill? We'll highlight the keywords. It is a draft of the legislative proposal, but when it is put in the proper form and it is passed by both the houses of parliament and it is assented by the president, then it becomes an act. So it is a draft, it is in proper form, it is passed by both the houses of parliament, it receives the assent of the president. Once the president approves it, then in that case it will become an act. That is why to pass an act, it has to go through so many stages. That is why you will always feel that when a bill is proposed, why does it take so much time to become an act? Why does it take so much time to be enforced? It is because of this reason. Then we have act. Yes, we already know that a bill, when passed by both the houses of parliament and assented by the president, this is very important, then it becomes an act. On receiving the assent, the act is then notified in the official gazette of India. Now, what is an official gazette? It is nothing but an official booklet which is issued by the central government. It was earlier printed in the press of the government. But yes, due to COVID, everything went digital. So all the library, okay, whatever it was the official Gazette library, that is now available online. You can visit the Gazette of India website. There you can go through all these, or you can go through the official Gazette. It is nothing but a booklet of public announcements. Now, the president has given his approval. The bill becomes an act. This only the houses of members of the parliament, the president knows about it, but the general public is not aware of any act being passed. How will you inform the general public? It will be through the official gazette. So this is a document which gives all the public announcements, and it is notifying the public that this act has now come into force. The act comes into force on the date on which either mentioned in the act or the date it receives the assent of the president. But if you have the date on which it is notified in the official gazette, then the act will come into force on the date it is notified in the official gazette. Then we have the definitions. What is the main purpose of definition? Definition means that we are trying to bring uniformity in the understanding of a term. We are trying to avoid repetition. Instead of explaining the concept again and again, we are trying to define it at one place. These are generally included in section 2 of the act, or sometimes they may be included under section 3 or other initial sections. Generally, we find them under section 2. Now, what is the object? What is the purpose of the definition clause? It is to avoid frequent repetition in describing the subject matter. So if a term is defined again and again in the act, wherever it is used, it will make the act very bulky. So we try to define the term once in the act, and then whenever that word is used, it will have the same meaning. If the word is not defined in that act, then you can refer the General Clauses Act. Step 1 is consider the words defined in the respective act. If they are not defined, then they can be taken from the General Clauses Act. Then what is the meaning of the word means and or include? Now, sometimes it says that it means and includes, or it says it means or includes. The word means, okay, the word means, it actually clearly and exactly defines the term. So if we say that a company means, okay, so when we say that a company means a company which is formed under this act or any other previous company or any other previous act, so you are trying to define what is the meaning of the word company. So the word means always tries to define. It is an exhaustive definition, but include is an inclusive definition. It means that it has a very wider scope. You say that debentures include debenture stock, bonds, any other instrument evidencing a debt. So you are actually trying not to define that term, but you're saying that this is also included, that is also included, this is also included, and it can include any other instrument evidencing a debt. So it is prima facie extensive. It does not define the word. It is only trying to provide that these things are included, but it may also include anything. It may also include something else. Then we have meaning of the word shall and may. Now you will find this in the interpretation of statutes also. Now the word shall is a better version. It is a politer version of should. I'll give you my personal example. When I was doing articleship and I was given the task of preparing the audit report. Okay, maybe just or a smaller report. I don't remember exactly, but it was a very small report. But being an article, it was a privilege for me that in my first year itself, I was getting to do independent audits, and I was also given to the task of preparing the report. Then the senior would only make changes or edits in that report. So it was my first report. I was not very much aware of it, and I used the words like the department should, the employee should. I used the word should. Then when my senior was going through my report, she said that you should not use the word should. You are just an article, or we are just an auditor. We are advising the management. We cannot be rude. We cannot, no, you should do this. You should, the head of department should. Instead of using the word should, use the word shall. That also shows that it is imperative, you have to do it. It shows authority, but in a polite manner. So the word shall is used to raise a presumption that something is mandatory, it is imperative, it means you have to do it, but we are just telling it to you very politely. It imposes an obligation. Yes, it is to be done. Like, say for example, we say that the report shall be signed by a director and a company secretary, or if there is no company secretary, by two directors. You are saying that it should be done, but we are only saying it politely. But if we use the word may, it is generally not mandatory, it is only directing, it is enabling, it is optional, it gives you a discretionary power. It is not making it compulsory. Like, say for example, that this report may be signed by the key managerial personnel. The word may says that okay, it may be signed by KMP, but if you don't want to do that, it's perfectly fine, it can be signed by the director. So in case of the word may, there is no imposition, and there will not be any penalty or any obligation. It will not constitute as an offense if you don't perform it. But in the word shall, yes, if you don't perform, it may constitute as an offense. You may be subject to certain damages or compensation. But here we are just trying to say that it is the word shall, it is mandatory, but we are only using a politer word for it. All right, students. So that was some basic meaning of few terms. Now we can jump to the definition. Students, if you are loving this revision lecture, if you would like to go for the chart book, we have a soft copy as well as hard copy available, and hard copy will be delivered to you at your residence address or whatever address that you provide us. Please go to my website theorymasterslearning.com. Link is in the description box, and you can make this chart book yours. The main aim of this chart book is that you keep it in front of you while you are studying. When you see those words, when you read those words again and again, it hits your mind, and it is very easy for you to remember those words. At Theory Masters Learning, we always aim to provide quality education. I feel that the student should get everything at one place, and with that aim, we have made this chart book so that you get everything at one place. You know what is to be studied. We always follow this policy, students. Since the beginning, it has been my aim that if you are our student, then you should get everything in one particular book or lectures, whatever you purchase. Once you're associated with us, you should have that confidence that the material that you're getting is the best material available. The lectures contain everything. I just want that you should feel confident when you go for the exam. Your concepts should be clear. So with that aim, we at Theory Masters Learning always aim to provide you with quality education. And as I mentioned earlier also, that this book is prepared 100% by me only. I have not delegated to anyone. I had done that. I had given it to 3 designers, but they did not give me the result that I wanted, the quality that I want to give my students. So in the end, I sat for 20 days. I did not do anything except work on this chart book, and I know in what flow I would want sections, in what flow it will be easy for the students. With that aim, I have designed the chart book. Each and every line, each and every color or a box has been designed by me. I've put in a lot of hard work on this, and I'm so happy, and I'm actually grateful and thankful to you for appreciating my effort. Students are loving the chart book, and that means the world to me. So let us continue with this. Yes, I got a little carried away, but you guys are so amazing, and I feel so blessed to be associated with students like you. I receive your messages. It makes me very happy reading your comments, your messages, and the fact that you are associated with me. I get to interact with students whom I have not even seen. Someone is in Assam, other are in Chennai, or maybe Bangalore, Mumbai, Jammu. I get to interact with students all across India, and it's an exhilarating. It's exhilarating that I'm just loving the work that I'm doing, and I would like to share that with you. So let's continue. Yes, then we have the meaning of word act. Now, what is meaning of the word act? Act actually has 2 meanings. Act can mean the act which you are studying, the General Clauses Act. You have studied the Partnership Act, the Companies Act. It is an act, but act also means an action. Over here, what we are discussing is action. Now, action can be positive, it can be negative, it can be favorable, it can be unfavorable. What we are going to study here is the unfavorable, the negative action, the negative act. Okay. The act can be an offense or it can be a civil wrong. So what they are talking over here is action and not the acts which we study. It shall include one act, it shall also include series of acts, words which refer to the acts done. The word include here means that it includes, which says that yes, if you perform one action, we consider it, but it also includes a series of action. Now, what is the meaning of series of action? Let's say that Mr. X kidnapped a boy. The act of kidnapping is a negative act, it's an offense. Okay, he has kidnapped, it's an act, it's an action, but he not only kidnapped a boy, but he also tortured that boy, he beat the boy. These are series of acts. Omission is also included over here. Omission means that we did not give him food, water, or kept that boy in some unhygienic condition, because of which the boy suffered maybe some illness. So that is omission, that is also included in the word act. It also extends to illegal omission. So if you highlight the words, it is illegal, it is civil wrong, it's an offense, it includes a series of acts. So they are trying to talk about the negative aspect of the word act. So these are different points to remember. These are the key words now. It includes act, it may be either positive or negative, but what we are trying to understand is the negative aspect of act. It may be a single act or a series of act. It also includes words. Okay, it covers omissions also, but only illegal omissions. It applies to civil as well as criminal wrong. How will I distinguish between civil and criminal? The act is considered as criminal only and only if there is intention, only and only if you can prove a guilty mind, only and only if you can prove mens rea. Mens rea means guilty mind. If you had intention to cheat, if you had intention, only then if you had a guilty mind, that is what distinguishes criminal from civil act. So only when we are able to prove that there is guilty mind, it will be considered as criminal. Then we have the meaning of the word affidavit. Oh, do we need to memorize all this? Yes, you need to memorize. That is why I have given it to you in a very simplified point-wise manner. I have broken the definition into small parts so that it is easy for you to remember. You can easily convert this into sentence form. Like, act can be used with reference to an offense or a civil wrong. Act shall include series of acts and words which refer to the act done. It also extends to illegal omission. The act includes both negative act. It covers single act as well as a series of act. Words are also included. It covers omissions, it covers illegal omissions, it covers it up. This definition applies to civil as well as criminal wrong. You can easily convert this into sentence form and you can convert it into easy sentences. That is what is required in the exam. Simplify the provisions. Then we have the meaning of the word affidavit. Affidavit means you are confirming. It includes an affirmation or a declaration in case of persons by law, persons allowed to affirm or declare by law. Okay, so it includes affirmation and declaration in case of persons who are allowed to do that by law. Now, what is the meaning of the word affidavit? You know, when you were small, you must have told your friends, no, I will bring your pen tomorrow. Then your friend tells you, write and give it to me. I don't trust you. We used to say that, no, out of innocence, or maybe, we didn't even know what we are doing. That writing and confirming is nothing but an affidavit. It's nothing but a declaration. I'll give you my personal example. My parents had gone for passport, and to make a passport you need to provide certain documents. Now my mother had all the documents required by them in her old name. Okay, and even if she had the documents in the new name, they were asking for a marriage certificate. Now marriage certificate is something which is in trend nowadays. The parents, grandparents may not be having a marriage certificate. So she said, I don't have a marriage certificate. How? Then they are like, how will you prove that you are married to this person? You want the passport in your new name. And then in that case they asked for an affidavit. So on a stamp paper they wrote that yes, we are married since these many number of years, and they attached their marriage photograph, marriage card. They signed a document affirming or confirming that whatever is written in the document is true and accurate to the best of our knowledge. And that written document, when they are declaring that we are married, and that is known as an affidavit. Affidavit, it has to be in writing only. It in by persons, in case of persons by law allowed to affirm or declare instead of swearing. Now swearing means you always swear, no, I swear I didn't do this. that is nothing but an affidavit only you're declaring. So in India, there is no difference between oath, affidavit, and swear. They all mean the same. Technically, they may be defined separately, but if you see practically, they all mean the same. Now, what is the meaning of an oath? Okay, oath means like in school, we would take an oath that I promise I will do this. So an oath is something which you're declaring, you're promising to do. So swearing, oath, affidavit, they all actually mean the same. So persons who can swear, they can also prepare an affidavit. So it is an inclusive definition, because see the word which they have used over here, it includes affirmation and declaration. So it's an inclusive definition. It does not define the word affidavit. It's a written statement. It has to be in writing. It is confirmed by an oath or affirmation. It can be used as an evidence in the court of law because it is written in a proper format. It is in writing. It is a legal document. In India, oath, affidavit, and swear, they mean the same. So if you are asked a question on affidavit, this is what you need to write over there. Then let us discuss the meaning of the word Central Act. Central means something which is applicable to the whole of India. Yes, so we have central acts, we have state acts. Central Act means the act of parliament. In our country, parliament is the legislative authority, it is the lawmaking authority. So it means act of parliament, but it should also include. So see over here, it is means and includes. Okay, so did you notice something? See over here, it is written means and includes, means or includes. Okay, so here it means an act of the parliament and it also includes. So they have defined Central Act as the act of parliament, but it also includes, so they have widened the scope of definition by saying that it also includes the act of dominion or Indian legislature. It also includes act passed by the Governor General in legislative capacity before commencement of the constitution. Now, our constitution commenced on 26th of January 1950. So the acts which were made before the commencement of the constitution, they are included. They also include the acts which are after the constitution, which are an act of parliament, that is also included. So it is widening the scope of the definition. Now, what is act of dominion? Before the constitution, that is before independence, I should say, we had Britishers ruling our country, but they were not present in each and every place or every state. They were present mostly in the states like Madras, Bombay. Yes, old names, Madras, Bombay, Delhi, Calcutta, in these major places. So these were known as polities, or they were known as a dominion. So wherever these Britishers were present, there in their polities, they were the lawmaking authority, that is the act of the dominion or the Indian legislature. But in other places wherein they were not present, other small places, they allowed the king to govern and to make laws, but the king was a mere representative of the Britishers. So the Britishers, they controlled that place through the king, because there were very small places and there were so many places where the king was present. So they controlled that place through the king, and the king then made the laws, and the person who made the laws on behalf of the king is known as the Governor General. Okay, the Governor General, he was the representative of the king, but the king was ultimately controlled by the Britishers. So any law made by the Britishers in those polities, any law made by the Governor General before the commencement of the constitution, that is also included in the Central Act. Dominion legislature. Okay, so I have explained the word over here, the dominion or the dominion legislature. It means the laws made between 15th August 1947, that is the day we received independence, till the constitution was made in the year 1950. So a representation of that act is that 15th August 1947 to 26th January 1950, this is the dominion or the pre-constitution laws are included, and the laws which were made after the constitution, that is these are post-constitution laws, they both are included in the definition of the Central Act. So Central Act includes, it means the act of parliament which was passed after the constitution was made, and it also includes the pre-constitutional laws. Not very frequently asked, but if it is asked, you can write this. It is a very simplified definition of Central Act. Then we have meaning of the word central government. Yes, sometimes they only write the word government. They don't specify whether it is central or state government. Then in that case, you have to see the context in which it is used. Now, what is the meaning of the central government? In relation to anything done before the commencement of this act. Okay, so we will highlight the word before. In relation to anything which is done before the commencement of the constitution, central government will mean the Governor General or the Governor General in Council, as the case may be. It shall include the provincial government or the Chief Commissioner. So here it will include before the constitution, governor general in council. So these are representatives of the king. They were lawmaking authority, the governor or the governor general in council. It shall include the provincial government and as well as the chief commissioner. In anything which relates to after the constitution is made, so after the constitution is made, we will find the president over here. It means the president, so Mr. President will definitely come over here, and it shall also include. So they have used the word means and includes. Okay, so if you notice, students, that means and includes, that combination is used so many times in the definition itself. It will mean the president and it will also include. So meaning it is the president, but it will also include the state government, the chief commissioner or the lieutenant governor, like in Delhi. It will include the administrator of the union territory. So we have the central government, we have the state government, we have the union territories, we also have the lieutenant governor or the chief commissioner. So laws which are made by them post constitution will be covered over here. Is this important for exam? I don't think so. But central government is divided into two parts, that is both pre-constitution, that is before the commencement of the constitution, and the second part is after the commencement of the constitution. So before the commencement, it will include the governor general in council. It will include the provincial governor or government or the chief commissioner. After the constitution, it will include the president, the state government, the chief commissioner, the lieutenant governor or the union territory. So we have the central, we have the state government, we have the union territory, we also have the chief commissioner or the lieutenant governor. Not very important for exam. Then yes, commencement, a question can be asked on this. What is the meaning of the word commencement? Commencement means to begin. You must have studied, know that the Companies Act came into force on, or the Contract Act came into force on. So yes, that is when the act comes into force. When does it commence? With reference to any act or regulation, it means the day on which the act or regulation comes into force. This is the act on which it comes into force. It means that is the act from which it is effective. Like the Indian Contract Act came into force on 1st September 1872. It means all the contracts which are formed after 1st September 1872, they will be governed by the Contract Act. Before will be governed by the English law. The Companies Act, it received the assent of the president on 29th August. That is the day on which it received the assent of the president, but it was notified in the official gazette on 30th August. So it comes into force on 30th of August, the day on which it received the assent, on the day on which it was notified in the official gazette. We had discussed the meaning of official gazette. We'll go to that directly. We'll jump to it. Official gazette means Gazette of India or the Gazette of state. So if we are using a general word, that is official gazette, it can mean either of the state or it can mean the official gazette of India, that is central. See, laws are made by both the central government as well as the state government. So state government will make law for the state. It will also have its own official gazette. So when we are using a general term, it may mean either of the state or it may mean of the center. These are the points to be noted. As I already discussed with you, it is a public journal. It is a legal document by the government of India. You can visit the website of the Gazette of India. You will find everything in the soft copy. So it is a legal document. It is published weekly. It was earlier printed on a weekly basis by the Press of India. It contains official notices, public announcements from the government of India. Now the act has been passed by the parliament, by the president's approval. How will the general public come to know about it? It is through the official gazette. The act comes into force on the day on which it is notified in the official gazette. If the date is not available, then you will go to the date on which it received the assent of the president. It is authentic, it is accurate, it is according to the government of India policies and decisions. So these are the key words, students. I have written all the key words in the chart book. These are the words which should be mentioned in your answer. So let us go through it. It means the official gazette of India, or it may be of the state. It is a public journal because it is containing official notices for the public from the government of India. It is an authorized legal document. It is published weekly. It is authentic, accurate, and according to the government policies. So the act comes into force on which it receives the assent of the president or the date on which it is notified in the official gazette. Law cannot be enforced unless it is brought into operation. All right. Then we have meaning of the word document. This is something you will read in the interpretation of statutes also. So what is the meaning of the word document? It means any matter which is written, expressed, or described upon any substance. Like many a times in articleship, we used to hear this word, please document this. Document means please maintain a record of this. How will you maintain a record? It can be on paper, parchment, but record does not mean only on paper. Like say for example, there was a war. Okay, so the war, a memorial is created, that it is a documentation of the event which had taken place. So we write the name of the soldiers who sacrificed their life in the war. So when you write all that, it is nothing but documenting. On the caves, the walls of the temples, so we have scriptures, we have drawings, we have inscriptions. Okay, or there are carvings, there are paintings inside the caves. These are all documentation, they are an evidence that the event had occurred. You can document it on a paper, parchment, wall, or a ground, or on the walls of the cave. Anywhere wherein you write, that is known as a document. It means it can include letters, figures, or more than one means. So it can be writing on the walls, or it can be drawings, it can be signs or symbols. It can be, it may be intended to be used, or which may be used for the purpose of recording that matter. So what is it? They are defining a substance which is intended to be used, or it is used for recording the matter. So you can record on any place. Like I have given you an example, even a CD, photograph, or a paper, these are all documents. They are used as an evidence in the court of law. But it does not include an Indian currency note. That is not a document. Like you may see on an Indian currency note, on the back of it, they may write, they may give, a certain events. All right, certain events or certain monuments are printed on the document. Like on the 20 rupee note, you have the Shanti Stupa. That is not a document. That currency may show that picture, but that is not considered as a document. All right. Then we have meaning of the word financial year. Now, financial year means the year which commences on the first day of April and it ends on the 31st of March. Now, it is a year which commences on 1st of April and it ends on 31st of March. It covers a period of 12 months. Since the word year is used, it is also inevitable that we define the year also. So what is the meaning of a year? Year actually means a calendar year. But since financial year is defined as a year beginning from 1st of April, we say that no, then this is not calendar year. Financial year means a year beginning on the 1st of April, whereas calendar year will mean the year as per the British calendar, which is 1st January to 31st of December. Now, if a question is asked on what is the meaning of the word calendar year, there is very little content. So you will also have to automatically explain what is a year, what is a calendar year, that is, it is as per the British calendar. Then we have the definition of good faith. Now, see students, if the definition is given in the act itself, then please refer that definition. Like say, for example, in the Partnership Act, they have clearly defined what is good faith. No need to come to the General Clauses Act. It is defined in the Partnership Act. Go and refer that definition. But if you don't find a definition in the respective act, it's a very general term. So now we have tried to define what is good faith. What is good faith? A thing shall be done in good faith if it is done honestly, whether it is done negligently or not. See, if you are doing the thing honestly, yeah, you may be slightly negligent, but you never had the intention to be negligent. Then in that case, it will be considered as if it is done in good faith. Now, how will you prove? See, intention is always shown through your actions. Now, let's say, for example, it's your mother's birthday and you buy a cake for her. You come on the scooter and there were a lot of bumps or speed breakers. When you open the cake and you say, Mama, happy birthday, you open the box of the cake and it doesn't look like a cake. Okay, it is all mashed and you cannot make out that it is a beautiful cake that you had purchased. So will your mom scold you? No, I don't think so. She will say, don't worry, beta, your intentions were, it was done in good faith. You were negligent. Yes, you were negligent. You shouldn't have taken the scooter. You should have come in an auto rickshaw, or you should have taken the car. You were negligent, but we accept because you did it in good faith. Nobody will scold you for that. So good faith, whether it is good faith or not, it is a question of fact. It actually depends on the facts and circumstances of the case. Like say for example, again, you must have seen that ad on television wherein a grandson tries to polish his grandfather's shoes and an entire shirt is spoiled, but the mother says, don't worry, we have Tide, or I think it was Surf Excel, I don't remember. So that was an act wherein the t-shirt was spoiled, but it was negligent. He was negligent, but it was in good faith. Okay, so whether it is in good faith or not depends upon the facts and circumstances of the case. It depends on the intention of the parties. It should be negligent or not. How will you understand that? See, because person will always lie that I was not negligent and I did it in good faith. So let's say for example that you had to sell goods to a few people, and you sold goods without verifying their solvency, without verifying their capability, credibility, you thought that there is no need. This act is not negligent. It is not considered to be in good faith. Okay. So you were negligent. Yes, you were negligent. You did not test, but it is not considered to be in good faith. Now, but what if you verified their solvency, you verified their credibility, you saw that they were capable of paying money only, then you sold the goods, and if they default, then we can say, yes, this act is done in good faith, it was not done negligently. Then in that case, no action will be taken against you. So anything done with due care and attention, it is not done mala fide. Mala fide means in bad faith. Okay. So it was done with due care. You were careful, you paid attention, you did not have any bad faith. Maybe that was considered as negligence, but since your intentions were good, we will consider as if the act was done in good faith. This definition does not apply to those enactments where you already have a definition of good faith. We studied this earlier also, no? Where the definition is available, you need not refer the definition in the General Clauses Act. Yes. Then we have meaning of the word government. Government can include both central as well as state government, but sometimes they use the word government. Please explain whether it is central or state. They have not mentioned that. Then law says the word government is generally used so frequently without specifying whether it is central or state government, then it is to be understood in accordance to the context in which it is used. It means you will apply the facts and circumstances, the intention, and then you will decide whether it is central or state government, how it is to be interpreted. Next, we have definition of the word immovable property. This is defined in the interpretation of statute also. Yes, definition is the same. It shall include three things. One is land. Then it shall include benefits arising out of land and things which are attached to earth. And it will include things which are permanently fastened to anything attached to earth. So land, yes, it is immovable. It cannot be moved from one place to another. Benefits arising out of land, things which are attached to earth, can include trees, it can include standing crops, it can include buildings. Anything which is permanently fastened to anything attached to earth. Now, let's say, for example, that I dug a hole, I installed maybe a stand like this and a chain, and on the chain, then I attached the machinery. Okay, so machinery is attached to a thing which is fastened to earth. Now machinery will not move because this thing is not moving. So machinery which is fixed to soil, it is fastened to anything attached on earth, that is also immovable. That makes the machinery immovable. Right of way of access from one place to another. Now there are two buildings. They are connected by, let's say, a small connection, you know, between two buildings, because the building is a high-rise building. People who want to go to the mid floor, so easily, you know, we can have lifts, we can have some kind of a connection between these two buildings. So this is the right of access from one place to another. Plus this is my house. Okay, and anything which is providing me access to that particular house, then that is also considered as a part of the immovable property. So there are three things. We have land, we have benefits arising out of land, which includes trees, crops, grass, anything which is attached for the time being, anything permanently fastened to thing attached. So I have, this is the thing attached, I have attached the chain, so that is also considered as immovable. Definition is very important for exam. You need to memorize it as it is. Imprisonment. This is one word which we have come across so many times in the Companies Act. Officers in default subject to imprisonment up to 2 years. What kind of imprisonment? Simple or rigorous? Act is not specific about it. They have not defined. It depends on the court. You decide whether you want to give rigorous imprisonment or simple imprisonment. Rigorous means something which involves hard work, like construction of roads or, you know, breaking stones. Simple imprisonment will have you doing simple jobs like washing clothes, cooking food, or making some handicraft. So whether it is rigorous or simple, they have not mentioned. If nothing is mentioned, then it is left to the discretion of the court. They will decide what kind of imprisonment the accused will be subject to. Official Gazette we have already discussed. So students, with this we finish all the definitions. Next, let us discuss the general rule of construction. Next, let us discuss the general rules of construction covered under section 5 to section 13. Now, in this, we have section 5 coming into operation of enactment. how to calculate dates and when does the act come into force. Now, many a times the act specifies that the act will come into force from this date. Sometimes they give the provisions they will come into force from this date. If the date is given, then the act will come into force from that day only. If nothing is given, then the date on which it receives the assent of the president. Now, the president has approved the act comes into force, but will has the general public come to know about it? No. So the general public will come to know only when it is published in the official gazette. So finally, if the official gazette date is given to you, then the act will come into force from the date it is published in the official gazette. So there are many options, there are many combinations where the central act has not specifically mentioned a particular day when it comes into force. That is, if the day on which the act comes into force is not mentioned, because that is the first option, the act will come into force from the date it is mentioned. But if it is not given to you, then if the acts were made before the commencement of the constitution, that is before 26th of January 1950, then the day on which it receives the assent of the governor general, as I already discussed earlier, governor general is the representative of the king. The day on which he gives the assent, that is the day on which the act comes into force. But if the acts are made after the commencement of the constitution, that is after 26th of January 1950, then the act will come into force on the day it receives the assent of the president. But if you already have with you the date of the publication in the official gazette, if that is given, then we will consider the date on which it is published in the official gazette at the date of commencement of the act. To commence means to begin. Okay, coming into operation of the enactment means when does the act come into force. So if it receives the assent of the president, but if the official gazette date is given, then that date. If gazette date is not given, then the date on which it receives the assent of the president. Now, this was about the act. What about the rules? The act is supported by rules. Wherever you see as prescribed, then that prescribed thing is given in the rules. The day on which the rules are published in the official gazette, that is the day on which the rules come into force. Fraction of a day is not considered very interesting. Now, the Companies Act, it was published in the official gazette on 30th August 2013. Now, the notice may appear on the website at, let's say, 11 o'clock in the morning. So you can't say that the act has come into force from 30th August at 11 o'clock. No, as soon as the clock strikes midnight, it means as soon as it is 30th August at night, that is the day from which the act comes into force. So it will come into force from the day the clock strikes midnight, and it is 30th August. Then section 6, it covers effect of repeal. Now, what is the meaning of repeal? Repeal means to remove or revoke. Sometimes the acts, they have completed their work, like say Amendment Act. Now, the Companies Act was introduced in the year, Companies Act was enforced in the year 2013, but there were so many amendments which came after that. In, let's say 2015, we have 2017, we have 2020. Now, these Amendments Act, the main aim of the Amendment Act is to make changes in the main act. Once their purpose is over, we no longer require these acts. So many of these Amendments Act are generally repealed. If you see the Contract Act, in that also you will observe that the provisions relating to partnership and sale of goods act, they have been repealed from the Contract Act, and a separate act has been formed for them. So repeal means to remove. Now we are removing these acts or these provisions, these parts in such a manner as if they never existed. Okay, so we are removing every trace of that act. So effect of repeal is that as if the act never existed, we obliterate, we eradicate or remove the provisions, or we remove the entire act in such a manner as if it never existed. Generally, if you see out of the many acts which were repealed, most of them were the Amendment Act. Now, amendment is one of the reasons that, the purpose is over, so these acts are repealed. Now, there are certain acts which are so old that they are no longer relevant, like Fisheries Act, maybe it was introduced in the year 1950. Now, there are so many changes which have taken place. You can't continue with that act. So, if the purpose is over, or if the acts lose their relevance, they may be repealed. Where any central act or regulation made after this act means the 1897 General Clauses Act, it repeals any act made or yet to be made unless any other purpose, the repeal shall not. Now, this can be asked as a theory question, so you need to memorize these provisions. Just because the act is being repealed, it will not affect the following. It will not revive anything which is not enforced or prevailed during the period repeal is effected. Now, if the act was not in force and you repeal it, it is not going to affect anything, no. Something that was not in existence, if it is repealed, that is not going to affect anything. Now, let's say, for example, there was one act and it was to be enforced from a later date, but we realize that this act is no longer relevant, so we repeal that act. Now, that act had not been enforced only, so will the repeal affect anything? No, it will not affect the rights of any person. It will not affect the previous operation of any enactments. Sorry. It will not affect the previous operation of any enactment so repealed, anything done or suffered thereunder. Now, let's say, for example, that I was supposed to pay compensation under some act and now the act is repealed. Can I say, now I need not pay compensation? No. It will not affect the rights, the damages which we had suffered earlier. It will not affect the operation of the enactment so repealed. So the contracts which were entered in those acts, the punishments which were given, or maybe you were imposed some fine, it is not going to be affected just because the act is repealed. It will not affect any right, privilege, obligation, liability obtained under legislation so repealed. So if maybe you had to pay penalty, or maybe you were suffering some imprisonment, or maybe there was some contract, maybe you were awarded some remedy, nothing is going to be affected just because the act is repealed. You will get all the rights, remedies, even the liabilities will remain as it is. It will not affect any penalty, punishment, or forfeiture with regards to any offense. It will not affect any inquiry, litigation, or remedy which may be initiated, continued, or insisted. Now, it is already initiated. See, you were planning to, then that is a different case, but it is already initiated. It is continuing. It will continue under the old act. The repeal will not affect the relations which have already been established. Now, Section 6A capital A shows that it has been added through an amendment. Repeal of act making textual amendment in the act or regulation. Now, the Companies Act 2013 came into force on 30th August 2013, but after that there were so many amendments, let's say 2015, 2017, 2020. Now, the aim of these amendment act is to make changes in the original act. Their work is over. Now I repeal these acts. I'm just assuming, okay? I'm just assuming that maybe these acts are repealed, but they must have made some changes. Yes, certain changes in the Companies Act. Just because these amendment acts have been repealed, they will not affect any textual amendments, any textual changes which were made in the original act. Where any central act or regulation made after the commencement of this act means that in General Clauses Act 1897, it repeals any enactment by which text of the act, regulation was amended by express omission, insertion, or substitution. So we may have made certain amendments in the Companies Act 2013 by adding, amending, or omitting certain provisions. Then unless some different intention appears, the repeal shall not affect the continuance of such amendment made by the enactment so repealed and in operation at the time of repeal. So just because we have repealed the amendment act, the textual amendments which they have made in the original act will not be affected. They will continue as it is. It is as if the repeal was never made. Then we have section 7, revival of the repeal act. Oh, we have realized our mistake. We have realized that these acts were not to be repealed. Oh, sorry, by mistake. Now, sometimes we may want to revive these repealed acts. So law says, yes, it is possible. You just need to mention the intention or the purpose for doing so. So we are not asking you for any sort of explanation. Just mention why you're doing it and what is the purpose. You can revive it. Nobody's going to stop you. If any central act or regulation, it is necessary to revive either wholly or partially. You're trying to revive either whole or part of any enactment. It is okay. You need not feel bad about it. Just mention your purpose or intention for doing so. Next, we have construction of references to repealed act. Now, in the Income Tax Act, in section 115JB, the book profits are to be calculated as per the Companies Act 1956. Now, the Companies Act 1956 was replaced by the Companies Act 2013. But unfortunately, let's say that we forgot to change the year, Companies Act 2013. So should we continue to calculate the book profits as per the provisions of the 1956 Act? Law says use your mind, yeah, use your brain. This has now been replaced by the Companies Act 2013. Now in this case, if suppose any reference is made, okay, if we make any reference of these repealed acts, that doesn't mean that you have to continue in cases we forget. Okay, here we have forgotten to make change, doesn't mean that you will continue to calculate the book profits as per Companies Act 1956. You will calculate the book profits as per the provisions of Companies Act 2013 only. Every act has its own distinction. If later act merely makes a reference to the former act or existing law, it is only by reference, and all the amendments, repeals in the new law will have effect. So whatever changes we have made, whatever repeals that have been made, whatever amendments have been made, that will continue to apply. Then we have commencement and termination of time discussed under section 9. This is very simple, students. You must have studied this earlier also. Okay, I'm not able to show it. I'll just adjust the screen a little. Yes. Okay, now see, in this case, how should we calculate the time? How are those days to be calculated? Let's say that a dividend is declared on 27th of Feb. We know that in case the dividend is declared, it has to be paid, or at least the warrants have to be dispatched within 30 days of declaration of dividend. So within 30 days, I am not able to adjust this. It's moving now. So it has to be paid within 30 days. Now, if it is not paid within 30 days, then the unpaid or unclaimed dividend will be transferred to the unpaid dividend account within the next 7 days. So how are these days to be calculated? Now the dividend is declared on 27th of September. So how should we calculate 30 days? What will be included and what will be excluded? 27th, that is a half day, will not be considered. We will start the calculation from 28 to 28, 29, 30. 3 days of September. To reach 30, we need more 27 days. So 27th October, by 27th October, this dividend has to be paid. It has to be claimed. If it is not, within the next 7 days, the amount will be transferred to the unpaid dividend account. So how should the calculation be made? Should we consider 27th October? No. Calculation will start from 28. So 28, 29, 30, 31, 1, 2, and 3. So by 3rd November, okay, by 3rd November, we should transfer this amount to unpaid dividend account. So the first day of the series is excluded. Last day is included. If it is from a particular day, then that from day is excluded and the to day is included. That is what is mentioned over here. Computation of time. Now, many a times we are given some specified time in the act to file a case. Let's say that the case should be filed within 60 days. Now, I went on the 60th day to file the case, but then I realized that the courts are closed on that day. I have been given 60 days. If the court is closed on the 60th day, it is not my fault. So law says in that case, you can file a case on the next day on which the court office is open. Oh, but the next day is Saturday. Oh, don't worry, Saturday, then Sunday, Monday, the courts are open. You can file a case on Monday. Okay, so the next day on which the courts, okay, what is happening? I'll just change the eraser. Yes. The next day on which the courts are open. So whereby any legislation or regulation, the act is allowing our action to be taken in the court or office on a certain day or within a prescribed time period. So I can take action, let's say on 15th of October, but unfortunately on 15th of October it is a holiday or it was declared as a holiday. Then the office is closed, or on the last day of the prescribed period it is closed. The act will be done properly even if it is performed on the next day on which the courts are open. All right. Then we have measurement of distance. Do you remember in Contract Act, section 27, restriction on trade? Yes, restraint on trade, that you cannot force a person to close down the business. You cannot, every person has the right to carry on business, trade, profession of his or her choice. So section 27 says that you cannot restrain a person from carrying on lawful business, trade or profession, but there were certain exceptions. Like in case of goodwill, I can restrict a person, let's say X sold goodwill to Y. Y can restrict the seller of goodwill X from carrying on similar business in a specified area. Now, I say that you will not carry on a similar business within 50 kilometers radius, okay, within the radius of 50 kilometers. Now, in this case, how is that 50 kilometers to be calculated? There is a mountain, there are hills, there are certain roads. Law says that the distance will be calculated in a straight line on a horizontal plane. So while calculating the radius of 50 kilometers, we will consider a straight line and not go above the mountain, come back. We will consider a straight line for calculating the distance for the purpose of the act made after the commencement of this act, unless there is some different intention appears. See, we are always giving the respective act some amount of freedom to make changes. If they don't want to do that, then the General Clauses Act is always there to advise that you will calculate it on a horizontal plane. Okay. Then over here, the last provision, gender and number. Very interesting, important for case-based questions. While importing the masculine gender, it shall include the female gender also. Like for example, chairman. Whenever I write the word chairman, you should never ask me, ma'am, is a chairwoman also included here? Yes, of course. That is why at many places they have now started saying the word chairperson instead of chairman. So male gender includes female unless some different intention appears, unless the act is very specific. When I use the word actor, it can mean a male actor or a female actor. It's a very common word now. So male includes female gender also, unless the act is very specific, like the male descendant, that word is mentioned in the act. So in that case, we will not consider a female descendant. If it is mentioned the word cattle, cattle is very general. It includes male as well as female. But if it is very specific, they use the word bullocks, then it means they are referring to a male gender and it will not include female gender. So unless there is some specific mention in the act, then we will consider it as gender specific. If it is not, if nothing is given, if it is a very general provision, then you will consider that male includes female also. Number singular includes plural and vice versa. Now let's say that the company has a policy that the KMP shall be a KMP in that company only and not other company. So if you are a KMP in company A, you cannot be a KMP in company B except the subsidiary of company A. So let's say the company A has subsidiary 1. Can you be a KMP in subsidiary? Yes. But can you be KMP in company B? No. You can be a subsidiary of, yes, you can be a KMP in subsidiary of company A. Now later on, the company acquired another subsidiary. We have subsidiary of company A. This is the second subsidiary. Now can this KMP continue to be a KMP in subsidiary 2 also? Yes, that's fine. Singular includes plural also. So if you have more than one subsidiary, then it is understood that you can be a KMP of company A and subsidiary, but that subsidiary word includes multiple subsidiaries of the same company also. So singular includes plural, plural includes singular. So with this, we come to an end of the general rules of construction. Next, let us discuss power and functionaries, section 14 to section 19. Next, let us discuss power and functionaries, section 14 to section 19. Now, section 14, it talks about power conferred to be exercisable from time to time. Now, what is the meaning of the word time to time? This is something which you will come across many times in the provisions, that whatever power we have given to you, that can be exercisable from time to time unless there is some change. Okay, so you can keep on exercising that power until the law amends it or it omits it, or there are certain changes which are made in that. Whereby any central act or regulation made after commencement of this act, means after the commencement of the General Clauses Act 1897, any power that is conferred, then unless a different intention appears, unless they are excluding it or unless they are saying that it is applicable only to a certain extent, unless there is some different intention, that power may be exercised from time to time as the occasion requires. So once we have given you certain power, like power may be given to the directors, to the members, it may be given to the company secretary. So if a power is given, then that power can be exercisable from time to time. Whenever required, you can exercise that power. Like directors have the power to declare interim dividend, you can exercise that power from time to time whenever you want to declare interim dividend. The members have the right to appoint the directors, to appoint the auditors in the annual general meeting, to fix their remuneration, so that can be exercisable from time to time. That is discussed under section 14. Now what I have done is I have broken down these into small manageable sentences. Okay, these are small parts. Now in the main exam you can write it in one single sentence, or you can write it in this manner, it is fine. Why have I broken the entire sentence into small parts? Because it is easy to remember. Section 15, power to appoint will include power to appoint ex officio also. Ex officio means someone who is in a position, okay, or because of his office, because of his office or position, okay, because of office or position. Now ex officio means someone who automatically becomes a member, who automatically comes into power, who is an automatic choice just because of his position. Now whereby any legislation or regulation of power to appoint any person to fill any office or to execute any function is conferred, then such appointment shall be made either by name or by virtue of office, and this also may be made by appointing ex officio. Now this is very closely related to substitution of functionaries. Okay, it is very closely related to this particular section. Now law says that if the certain power is given, like you have the power to appoint, then that appointment can be made by name, or it can be made by virtue of office. Now let's say for example you want to write the name that we are going to appoint Mr. Iyer in this position, but in case you don't want to name someone, because persons may change. So today Mr. Iyer is in that office. After a few months or weeks he may leave the company, and we may appoint, let's say, Mr. Sharma in his place. So you need not write the name of the person. It is okay if you only write the office, like the CEO of the company, like the director of the company. So you can, instead of writing the name, write his office. Under this section, it states that where there is a power to appoint, the appointment may be made. Okay, it is not compulsory. They have used the word may. It may be made by appointing ex officio as well. Ex officio means that person is a natural choice because of his position, because of his office. Like say for example, like you have organized an annual day function in your college. You have invited someone as a chief guest. Now that person is unable to make it. Okay, last minute he cancels that I cannot come. The next obvious choice will be your principal. So you can go and request the principal to please become the chief guest, because he's a natural choice. You will not go to the peon and tell him that you become the chief guest. So because he is in office, he is the natural choice. Let's say for example you have formed a provident fund committee. In that case, or a provident fund board. So in that case, the ex officio, that is the provident fund commissioner, he is a natural choice. He is an automatic member of that company, of that committee. You need not question his authority. He is a natural choice. He automatically becomes a member of that committee just because he is the commissioner, just because he is in that office. It is because of his position. So that person is an ex officio. So law says that wherein you have the power to appoint any person, then such appointment may be made either by name. So you can say Mr. Iyer is going to be appointed at this position, but instead of writing the name, you can also say that the director or the managing director of the company will be appointed, and at that time whoever is the managing director will be appointed to that position. Okay, so along with this, let us also discuss section 17, which is substitution of functionaries. Instead of writing the name, because we know persons may change, so instead of writing a name, it is fine if you just write the designation. So whoever is appointed at that place at that particular time will automatically be considered for that position. In any central act or regulation made after the commencement of this act, you will find that this is a very common sentence. Yes, for the purpose of indicating application of law to every person or number of persons for the time being in force executing the function of office. It is okay if we mention the official title of the officer at present executing the function, or that of the officer by whom the functions are commonly executed. So they simply want to say that in case you have in case the law applies to every person or a number of persons, instead of naming the persons, it is sufficient if you just write the function that the person performs. So you can simply write that this task will be performed by the company secretary, this task will be performed by the director. So whoever is the director, whoever is the company secretary, will automatically that particular provision will apply to him. Successors. Okay, let's do successors. It is sufficient for the purpose of indicating the relation of law to the successor of every functionaries or of corporations having perpetual succession. Now, what is the meaning of successor? Successor means someone who is going to succeed your position. So law says that the rules which apply to a person will automatically apply to his successor also. We need not have separate rules for him. Like for example, you are applying certain functions to the president. So automatically these functions will be applicable. They can be carried out by the vice president also. What if the president is busy? What if he cannot perform his function? And automatically that function will be performed by the vice president. If suppose the let's say for example, in case of a company, yes, the director, it is to be performed by a particular director. If he is not available, then it can be performed by his assistant or associate director. Okay, associate director, it can be performed by his associate director. So it is very natural that if certain rights are given to a person, it can be performed by his successor also. Or in case of corporations having perpetual succession, see, your corporation is not going to get over in this year at the end of the financial year. It is going to run till it is wound up. So in that case, people may come, people may go. The rules which are framed for a particular person will apply to his successor also. To express relation to functionaries or corporations. All right. Power to appoint will also include power to suspend or dismiss. This is the basic objective of the General Clauses Act, to reduce the language of law, to shorten the language of law. Law says that you need not specify this every time, that if the person can appoint, he can also suspend and remove. It is understood. You only need to write that this person can be appointed. It means if I have the authority to appoint you, I will also have the authority to remove you, to suspend you. The authority having for the time being power to make appointment will also have the power to suspend or dismiss. So you need not specify that separately. Don't write lengthy provisions, just shorten the language of law. So any other person appointed by itself or any other authority in exercise of that power. So it's a very simple provision. Then we have official chiefs and subordinates. The law relating to chief or superior of an office shall also apply to the deputies or subordinates. It is very similar, yes, to the point of successor. They are saying it shall be sufficient for indicating the relation of law to the successor of functionaries. So the laws which are applicable to the main authority will automatically be applicable to the successors, to the chief also. Now let's say for example, the president is busy. So it is okay if the vice president performs his task. If the director is busy, it is okay if the associate director performs that task, because it applies to successor also. That function can be performed by the successor also. The law relating to chief or superior, the laws which are applicable to superior will automatically apply to his juniors also. Like in case of audit, there are laws which are made for the auditor. Now the auditor is generally partner of the firm. Let's say he's a partner of the firm. Okay, so if the law is applicable to the partner of the firm, but partners don't perform that task, they delegate it to the manager and the manager delegates it to the articles. The partner is supposed to exercise due care, diligence while performing his duties. The article is also expected to perform the task with due care and diligence. If the article is negligent, then the partner will be liable. You cannot say that no, the article has performed that task, I don't know anything about it. You will be responsible for any task performed by the subordinate. So law relating to partners, the manner in which he is expected to perform the audit, that is the same manner in which the manager is also expected to perform the audit, and that also applies to article. So the law relating to chief or superior shall also apply to deputies or subordinates lawfully performing the duties of that office in place of, so this is very important, in the place of their superior, to prescribe to the duty of the superior. They have only used confusing sentences. You can write it in your own words, saying that the duties which are applicable, the rights the duties in performing a function which are applicable to the superior will also apply to the subordinate who is performing those duties in place of the superior. That is what happens in the organization. The higher level of authority only delegate the task to the lower level of management. So the subordinates will perform the task in the same manner as it is expected to be performed by the superior. The last part, that is provisions as to orders, rules, etc. made under the enactment. Now, we have always studied the rules, provisions applicable to the main act. Okay, so any act or regulation, we have always studied that. But what about the orders or rules which are made under the enactment? Because even, let's say, the Companies Act, it is supported by so many rules. Whenever you see the word as prescribed, where is it prescribed? You have to go to the rules. So provisions will apply there also. Construction of orders under the enactment. Now, what is the meaning of the word construction? This we are discussed in interpretation of statute. So it is always better that you study interpretation before you go through the General Clauses Act. In interpretation of statutes, we are discussed the difference between interpretation and construction. Interpretation means going through and understanding the provisions as it is without applying your mind. Just go by the language of law. But construction means applying logic, facts of the case. That is beyond interpretation. So how do we understand, how do we interpret the orders issued under the enactment? Whereby any legislation or regulation, a power to issue any notification, order, scheme or bylaw is conferred, then expression used therein shall have the same respective meaning as in the act, rules or act or regulation conferring the power. It is so complicated, but actually it is very simple. It only appears to be complicated. Now, first let us understand what is the meaning of this word etc. They have written construction of orders. Okay, what is included in this word etc.? For that we will go over here. Notification, order, scheme, rule, form, bylaw. So the provisions which we are studying not only apply to orders, but it also applies to notification, order, scheme, rule, form, bylaw. Now, what is bylaw? Bylaw is just like a law. Now, laws are framed by the center or by the state, but you may also have local laws, right, which are framed by the municipality or the Gram Panchayat. So they are just like a law. Okay, so how do we interpret the terms which are used in these order, notification, law? I'll give you an example which we have mentioned over here. The term collector used in Rule 4 of the Land Acquisition Companies Rules 1963. Now that collector word is used in the rule, but it is not defined over there. It will have the same meaning as given in the Land Acquisition Act 1894. So the rules, the terms which are used, the words which are used in the rules, order, notification will have the same meaning as it is given in the act. That is what is mentioned in this section. So where you have the power to issue notice, notification, order, scheme, the expression used therein, the words which are used therein will have the same meaning as given in their respective act. That is section 20. Then let's come to section 21. Power to issue will also include the power to add, to amend, to vary, change or rescind, cancel notification, order, laws, rules, bylaws. This was given earlier also. If you have the authority to make the rule, you will also have the authority to amend the rules or to amend the notification. You will also have the authority to vary, to change it or to rescind, that is to cancel it. Whereby any legislation or regulation, the power to issue notification, orders, rules, bylaw is conferred, then that power is exercisable in the like manner. You also have the power to add, amend, vary, rescind any notification, order, rules or bylaws so issued. So the person who has the authority to make will also have the authority to amend it. Then we have provision as to offense punishable twice, punishable under 2 or more enactments. Now, this is important for case-based questions, students. You cannot be punished for the same offense twice. Now, let's say that you have committed some mistake. Your mom has punished you that you will be grounded for a day. Dad cannot come and tell just for a day. No, not possible. It should be for a week. Dad, I have already been punished. Please don't punish me for the same mistake twice. Okay, so law says that if a person has committed an offense, he is punishable under a certain act. You cannot say, no, we want to punish him under that act also. He is already being punished. You cannot punish him for the same act twice. But do you remember we had studied in the initial part of this video the meaning of the word act? Act includes a single as well as a series of acts. What if a person has committed kidnapping, torture, rape, attempt to murder? He has committed a series of acts. Now you may be punishable for series under different acts. Like for example, rape, he may be punished under a certain act. For torture and for affecting the rights of that female, he may be punished under some different act. Okay, so for those series you may apply different acts and different sections, but you cannot punish the person for the same offense twice. Where any act or omission constitutes an offense under two or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments. So you, if two or three are applicable, you decide which punishment is to be applied. But he shall not be punished for the same offense twice. Okay, he cannot be punished for the same offense twice. Then extremely important for exam, I cannot even go to tell you how important this is. No number of stars will explain that. It is very frequently asked in the exam, theory case-based question. Meaning of service by post. Yes, we have studied in management and administration in the Companies Act that you need to send notice, you need to send annual report. There are so many documents which are sent to the members, which are sent to the ROC. If you are sending these documents by post, that way you have many options. You can send by post, you can hand deliver it, you can also send by electronic mode. But if you're using post as a medium of communication, then see, you cannot wait for the other person to receive, to give your proof that they have received the document. Like say for example that for a meeting we need to give 21 days of notice. Okay, we need to give 21 days notice for the meeting. Law says that sometimes the post may reach in 2 days, sometimes it may reach in 10 days, sometimes certain locations it will reach in 12 days. So should we wait for each person to receive the notice and then we start calculating whether he has received 21 days of clear notice? No. Law says that you can consider that he will receive it after 2 days, even though he actually receives it after 7 days. You start your activities considering that after 2 days he must have received it. You're assuming it. But when can you say that the letter is properly sent by post? Now, if it is properly addressed, all right, if we have prepaid the stamp, okay, and we are sending it by registered post. If you have done this, then we will assume that you have done your part as a company, you have done your part as a person, other person may have received it properly. So unless a different intention appears, service shall be deemed to be effected. We are satisfied if you have properly written the address, if you have sent, prepaid the stamp, if you have sent by registered post. Letter containing the document will be effected at time. We will consider that it is properly posted, he must have received it on time, at which the letter would have been delivered in the ordinary course of post. So generally, if it takes 2 or 3 days, we will consider he may have received. Why? Because you have sent it, you have properly addressed it, you have prepaid the stamp, and you have sent by registered post. So you can assume that he will receive it. After 2 days or 3 days, whatever is mentioned in the act, you can assume that he may have received and you can proceed with your activities hence. Okay, so you have to remember these words. There are a few cases, there are a few questions relating to it. You will find those questions in my compiler bomb, and if you want the link of the compiler bomb, I'm leaving it in the description box. Just visit my website theorymasterslearning.com and you will be able to find the compiler which has all these all questions asked on these important concepts. Okay, so do visit my website theorymasterslearning.com. Students, if you need a detailed question bank containing all exam questions, past exam questions, study material, RTP, MTP questions, then do buy the compiler. It is the best book that is available, and it will help you to clear the exam in this attempt itself. Normally what happens is students don't write and practice. They don't know what kind of questions will be asked. They don't know how to start the answer, what to write in the answer. So this book will give you full length answers and you will be able to apply these concepts well. So do visit my website, and there is a lot of material available in the e-notes section. There are a lot of downloadables available. So a lot of content is available. So I think you should visit the website once. Yes. All right. And with this, we also come to an end of the General Clauses Act. Students, I hope you're enjoying these lectures. Do leave your comment in the comment section. I love reading your feedback. General Clauses Act 1897, yes, we conclude over here. If you are looking for lectures, interactive sessions, interactive lectures, books, test series, then do visit my website theorymasterslearning.com. We provide regular courses, and we are also, yes, very soon coming up with crash course for CA Inter. So if you're a November student and you are following these lectures closely, but you would also like to learn all these concepts in detail with us, then do check our website and also follow us on your channel Theory Masters Learning, because we are very soon going to announce the crash course for CA Inter, Corporate and Other Laws. So with this, I'll take your leave, students. All the very best for your exam, and keep watching your channel Theory Masters Learning and hit the bell icon so that you get notifications for all the videos.